We're here today at the SEAK National Workers' Comp and Occupational Medicine Conference with workers' compensation attorney Bruce Bonds. Attorney Bonds, what's the best way for an employer or self-insurer to recognize a potential high-exposure claim?
Well, Steve, some of them are obvious. Somebody comes into the emergency room having fallen 35 feet and has no function of their legs. That's pretty obvious. The harder part is looking at the ones that are ambiguous or you're not sure how they're going to be. Any case where there's a serious injury is potentially high exposure. But as we have an aging workforce, injuries don't have to be as severe to create high exposure. Classic example being a 50 or 60-year-old person who's worked overhead laying brick all their life, has a torn rotator cuff, has a permanent 50-pound lifting restriction, can't go back to that job. Voila, you've got a high exposure case. So those are the kinds of cases that need special attention. And then, of course, you have the ones that are brought by people who are repeat offenders that have filed case after case. Those kind of speak for themselves.
So how can an investigation and surveillance be used effectively in these claims?
Well, it depends on what point in the process you're at. The investigation needs to take place very quickly. I would only do surveillance early on if there was a case where we really suspected the person wasn't injured at all. By way of investigation, I'm going to look to see whether there's a pattern of claims. I want to know if he had prior injuries, prior similar injuries. I want to know if he or she had prior restrictions. There's been times when I've done an investigation and found the person was previously restricted beyond what they are now. All those kinds of things factor into it. Perhaps the most important, though, is we want to see all the medical records, and particularly the medical records that start with the date of accident, the first history to the original treater, and I want to compare that to what's on the accident report filled out to the employer down the road a few days or weeks when, hate to be cynical, perhaps they've hired an attorney.
And so we talked about prior medical records. How does an intensive review of prior medical records help an employer defend a catastrophic claim?
Well, as I mentioned, if you can find out what's happened in their past, perhaps this is an injury that already existed. And you might, as I mentioned, see that there's permanent restrictions that they already were brought to the workplace. So you really need to see what's going on. Also, I want to see if they've had treatment by doctors who they haven't revealed to us. Okay, maybe they're hiding something. So if I get all the records, there's tons of little tidbits in there. I also want to see whether they've claimed it, told them at the billing office at the hospital that was work comp.
So last question, what should an employer do about severely injured workers to try to motivate them to return to work?
Create relationships, especially in the clearly compensable case. Reach out to them immediately. Studies I've read have shown that the most single important factor in predicting a good result and a quick return to work is the employer supervisor, and the insurance adjuster visiting the injured worker in the hospital or at home as soon as possible after the accident. And bring them a fruit basket, create a relationship, show them that you care, and ask them questions. What can we do for you? What is bothering you? What, if any, concerns do you have? That's the first step in developing relationships that will end with a quick return to work.
Thank you very much.
Thank you.